I will be talking about the new rules to Pardons Canada and how this will affect individuals with criminal pasts. In order to remove your criminal record from a public record, you must first apply for a record suspension, also known as a pardon. In March of 2012, the eligibility requirements for the waiting period for summary offenses had changed. They had changed from 3 years to 5 years, which evidently changed the lives of many individuals with a criminal record. With the new Liberal government, they are considering new changes in order to improve the lives of individuals with criminal offenses. For the current legislation, it is very important to take into consideration all of the eligibility requirements for a record suspension, not only the waiting period. For instance, the individual must have been convicted of an offence in Canada under the Canadian Federal Act or Regulation. They must have not received an absolute or conditional discharge of the offence. They must not have been convicted as a young offender for the offence. They must not have been convicted of a Schedule I offence under the Criminal Records Act. They must not have been convicted of 3 offences or more, each with a prison sentence of 2 years or more. They must have completed all of these sentences. And last but most importantly to this video, they must have completed all of the waiting periods. Keep in mind, these waiting periods only start after the sentences have been completed in full. As of right now, individuals with a summary offense are to complete a 5-year waiting period from the date of their completion of their sentences. On the other hand, an individual with an indictable offense is required to complete a 10-year waiting period after the completion of all of their sentences. These new changes are as a result of the Conservative government's new legislation that was brought into effect on March of 2012. Interestingly enough, Pardons Canada actually found these new legislations to be unfair and punitive for individuals with criminal records. In addition to Pardons Canada, other organizations actually fought against these new changes. However, they were all unsuccessful as the new changes have actually gone through and are now in effect. Due to the elongated waiting periods, many individuals have been negatively affected by these changes. In April of 2017, BC Supreme Court actually ruled that these new implemented waiting periods have actually affected the lives of the offenders and violated their Charter of Rights and Freedoms. This is especially the case if they were convicted of a summary or indictable offense before the new legislation came into effect in March of 2012. The new rules violate 2 sections of the Charter of Rights, specifically pertaining to the offender not being punished twice for the same offense, as well as having the benefit of a lesser punishment if a new legislation comes into effect while they are still in the criminal record system. Thankfully, similar to the BC Supreme Court, the Ontario Supreme Court is looking to make the same decisions. The new legislation continues to be implemented to all offenders, regardless of when their offences took place. Conclusively, the Parole Board of Canada is still indecisive of what to do and is still waiting for the Canadian government to make a decision. Thankfully, the Liberal government is hopeful and willing to reconsider the changes that have been made in March of 2012 by the Conservative government, although no changes have been made as of yet. In conclusion, it is very devastating for any individual who had waited for 3 years after they had completed their sentences, only to find out that they will have to wait another 2 years after these new legislations have been put into place. Criminal records not only affect a person's lifestyle, but can also affect their career and their future travels. Therefore, it is very essential that the Liberal government consider these new changes and investigate further to try and see if they can come up with a solution for these individuals with criminal records. Hopefully, a solution can be made in order to improve the lives of people with criminal records that are looking to apply for a record suspension and a pardon. If you have a criminal record and would like to pursue a record suspension or a pardon, we can definitely help you with the process. Here at Akrami & Associates, we have dealt with many immigration matters and can help you apply for a record suspension. If you have any questions, definitely contact us. With Akrami & Associates, there's always a way.